How many people can you provide advice to before you have to register as a commodity trading advisor? That's a trick question. Under 4.14A10, which provides exemptions from registering as a CTA, it says that if during the course of the 12 months prior, you have not provided commodity trading advice to more than 15 people and you don't hold yourself out as a CTA, that you don't have to register as a commodity trading advisor. And that is based on 4M1 of the Commodity Exchange Act, which is codified as 6M1, which says that you have to register if you're providing commodity trading advice for money. However, it doesn't apply to people who within the preceding 12 months have not furnished commodity trading advice to more than 15 people and don't hold themselves out as a CTA. So where the problem is everyone focuses on the 15 persons part and no one focuses on the shall not hold yourself out to the public as a CTA. And what does that mean? So here's a case, Mr. Lavender, that the CFTC brought a action against in 2000 for failure to register as a CTA. And what was the violation? He started holding study groups at his house to teach people how to trade commodity futures and then try to do it for others and charge them money. And one of his friends recommended him to somebody else with whom Lavender had no previous relationship. And that one instance where you said, I do this for money, that's holding yourself out. So even with one client that you held yourself out, you can't take advantage of that exemption. There's two parts to that. You have fewer than 15 clients and you don't hold yourself out as somebody who does this for money. Well, how do you get clients if you don't tell people that what you do? Well, here's an old letter that's still applicable, 9726. So this is from the Division of Trading and Markets, which doesn't exist anymore, but it still applies. And here they said that if the CTA restricts his clients' friends, family, and existing business associates, that won't be considered holding yourself out as a CTA. But if you introduce yourself to new people and you say, I do this for money, you're holding yourself out. So the friends and family thing is kind of obvious. Is there a professional relationship where this would apply? Sure. In a prior life, I was an M&A attorney and I had many energy clients. And if I was providing legal advice on something and they asked me something else related to commodity trading, I don't have to turn off the clock and say, I'm not allowed to answer that question. And in that instance, I wouldn't be holding myself out because that client doesn't know me as somebody who is a commodity trading advisor. They know me as a mergers and acquisitions attorney. And the advice that I'm charging for is related to what I'm doing for them, but in a different capacity. But I'm not holding myself out as someone who does this for a living. It pops up on an ad hoc basis. The same would apply if I'm a financial planner, if I'm a tax attorney, things like that. So I'm not holding myself out as a commodity trading advisor. I do something else for them in a professional capacity, and this thing comes up from time to time, but that's not why they came to me. So that's why I'm not holding myself out as a CTA. And the previous letter I mentioned, where it talks about restricting yourself to friends and family, you know Vinny Bag of Donuts because you went to college together, and you know Petey Pots and Pans because he's your brother-in-law. You don't know them because they solicited you to trade commodities when you met them at a dinner party. So that's why they're not holding themselves out, but you going out and soliciting clients, even if it's just one person, as was the case with Mr. Lavender, just one person is enough because you held yourself out to one person as a CTA. You have to register because it's a two-part test, less than 15 people, and you're not holding yourself out. You have to meet both those tests. So one is enough. Letters are pretty old. Do people get in trouble for this? Sure, all the time. Here's a case from 2015, Summit Energy Services. So most of their clients were commercial entities that traded natural gas and electricity. And even though these were large commercial entities that didn't need the protections, they can look out for themselves, they were still given advice about trading in swaps and futures to hedge their exposure by Summit Energy, and Summit Energy was not registered as a CTA, and that's why the CFTC went after them. And I have a friend who was a director at a large investment bank, and he left to start a fund. And he asked me how many clients he would have to have before he needed to register. And I explained to him what I'm explaining to you now. And he was not happy about it, but I gave him a great workaround where he didn't have to register and it didn't cost him anything, but I won't tell you what it is. But I will give you this information that I just gave for free. And if you're wondering why,
I make nothing. Zero. Zilch. By the time I pay all my scientists, all my people in my research department, lab coats, it's a wash. Well, why you do it then, baby Billy? Well, because I'm selfless.
well, that's not the only reason. And if you got something useful out of this, why don't you like this video and subscribe to the channel so you'll see future updates. So if you're wondering who I am, my name's Pete. I'm an attorney with 25 years experience in mergers and acquisitions, finance, futures, options, derivatives, you name it. And I'm putting these videos out there. And I'm going to give you a caveat that this is not legal advice. This is for information and entertainment purposes only, and this does not create an attorney-client relationship. You should seek your own legal counsel based on your own facts and circumstances.